The question of an employee being able to sue their employer is one which has been opened up by the Employment Act. As a matter of fact, the Employment Act provides that once an employee alleges the burden of proof or the requirement to disprove is placed on the employer. The employee's entitlement to fair hearing, to warning letters and that kind of thing is something that is dependent on the circumstances. Where it is a matter of fact, what we typically would expect that an employer would do is that an employer would first issue a show cause letter that allows the employee to respond. The employer would then proceed to have a hearing where the employee is also able to table their evidence. Indeed, the law allows the employee to be accompanied by another employee. And finally, the panel that is making the decision would then reach a decision on what kind of action should be taken. The law does not require that an employer take a specific course of action before another. So, for example, it is not a requirement of the law that a warning letter must be issued before a termination is done. Indeed, there are instances where it is not possible to do that. But it would be important for an employer to consider the weight of the matter, the weightiness of the matter before the employer, before taking the appropriate action as far as that goes.